Thank you, everyone, for joining us for today's webinar. We recognize that today is a heavy day in the immigration law community with the decisions on TPS and asylum. So just thank you for being here, in spite of everything that's going on. We hope that this webinar will be useful for you. So my name is Kelly Byrne. I'm a staff attorney at ASISTA, and I'm joined by my colleague, Christina. Do you want to introduce yourself?
Hi, y'all. I'm Christina Velez. I'm the Legal and Policy Director here at ASISTA.
Thanks, Christina. And so this webinar is on the impact of the policy manual updates on immigrant survivors, and specifically the updates to the policy manual on VAWA self-petitions and 1367. Next slide, please. So this is just the OVW disclaimer. We thank OVW for their support of our training and TA work. Without OVW, today's webinar would not be possible. Just a reminder to everybody that the opinions, findings, conclusions, and recommendations here are ours and do not necessarily reflect the views of the Department of Justice. Next slide. So for our learning objectives, by participating in the session, the hope is that you will be better able to describe the policy manual changes regarding VAWA self-petitions and 1367, to determine how USCIS might adjudicate certain case types after implementation of those new changes, and then to adapt your practices to those new requirements. Next slide. So for today's agenda, we'll start with the VAWA self-petition changes, then we'll break for some Q&A, and then Christina will take us through the changes to 1367, and then throughout we'll be talking about guidance on how to enhance USCIS adjudicators' perception of a survivor's credibility. Then we'll do more Q&A at the end and takeaways. And this is meant to be interactive, so we definitely want to hear from you all about what you're seeing in your cases. So please feel free to participate and put your thoughts in the chat throughout the webinar. Next slide. So we'll start with VAWA self-petitions. Just a reminder that these policies went into effect on December 22nd of last year, and they apply to petitions that were pending on that date, as well as petitions filed after that date. So they are retroactive. Next slide, please. So the first thing we'll talk about are the evidentiary changes in the policy manual. So as everyone probably knows, there's an important evidentiary standard for VAWA self-petitions. The any credible evidence standard doesn't mean that there's a lower burden of proof, but the idea is that VAWA self-petitioners have a wider range of acceptable evidence to meet their burden by the preponderance of the evidence. USCIS has conceded that the standard is statutory, but they have really honed in on the part of the statute that says it is within USCIS's discretion to determine what evidence is credible and what weight to give to that evidence. And they have a lot in here about what they consider to be credible evidence. They note that credible evidence is both externally and internally consistent, that it's plausible, and that it is also sufficiently detailed. So at ASISTA for a while now, we've encouraged practitioners to submit detailed and specific affidavits from survivors even before these changes came out, but that's going to be even more important now, given this new scrutiny on the any credible evidence standard. In terms of affidavits, USCIS has said that they should contain pretty extensive detail about the person writing the affidavit, including their address and their place of birth. So this is a consideration, not saying that you have to always follow that advice, but this is a consideration for if you're getting affidavits from other people in support of the survivor self-petition. USCIS has stated that they will give less weight to affidavits that lack that demographic information. You'll also see that USCIS focuses a lot on, in the policy manual, on corroboration and the importance of corroboration. We recognize, and USCIS should recognize, that there are some VAWA self-petitions where there is not going to be a lot of corroborating evidence. In fact, that is often because of the abuse. If you have a situation where there is truly no corroboration for one or more of the VAWA elements. It's not an impossible case, but that is going to be a difficult case to win in this environment. And that's something that the survivor should understand before deciding whether or not to file. All that said, you can, of course, push back on the corroboration requirement. You could argue that it's ultra vires to the statute. The statute only requires credible evidence, it doesn't require corroboration. And evidence can still be credible, it can still be detailed, specific, and internally consistent, even if it's not corroborated. In terms of photos, which I know a lot of folks use to prove some of the VAWA elements, USCIS has also imposed some new requirements on that type of evidence. One of them is to identify the photographer and when and where the photo was taken. I will say in technical assistance, even before these new policies came out, like I did see scrutiny on photographic evidence. So I don't know that this is necessarily that new, but the fact that they're codifying this in guidance shows that they're going to be having more scrutiny on photographic evidence. So just be sure to, if it's safe and possible to do so, include information about who took the photo, when was it taken, where was it taken, and a caption describing what is in the photograph. They also talk about psychological evaluations, which I know, shouldn't be required, but I know that a lot of folks use in these types of cases. With these types of evaluations, USCIS wants either proof that the evaluator is treating the survivor so that they have an ongoing therapeutic relationship with them. It's not just this one-time evaluation. Or if it is a one-time evaluation, they want proof that the evaluator actually thoroughly and adequately evaluated the survivor. And the way to do that is to make sure that the evaluation contains sufficient details about what the survivor shared with the evaluator, professional experience, and how this evaluator used their professional experience to come to a diagnosis for the survivor based on what they shared. So you want to make sure that evaluations have that level of detail in them, which is consistent with a lot of other information coming out from the immigration agencies recently. There's also a lot of emphasis on the outcome of false statements. So in the policy manual, USCIS, when talking about credibility, has noted that if the survivor in the past had submitted a fraudulent document or knowingly made any type of a false statement, that can undermine the credibility of all of the evidence in the self-petition, not just evidence in the area where there was a false statement. So that is something important to keep in mind if the survivor, for example, might have made a false statement to border officials when they entered the United States. The fact of that false statement could make them appear less credible when testifying to, for example, battery or extreme cruelty or good faith marriage. So in those cases, it's going to be even more important to try to get corroboration or have the survivor explain why that doesn't exist, to connect any potential false statements to the abuse if possible, and make sure that the affidavit is internally and externally consistent and detailed. I will say that this guidance in practice doesn't seem particularly new to me. I've seen in technical assistance USCIS cast doubt on a survivor's credibility because of a past history of false statements. But again, the fact that they are now codifying it in guidance shows that they are becoming more focused on fraud and false statements. And then I will also note that if the survivor's false statement was connected to the abuse, you can argue that because of that, the statement's not voluntary, it was coerced. And if there's a involuntary false statement that actually doesn't tell you a lot about a person's tendency to either tell the truth or not, and it actually doesn't render the survivor less credible. USCIS shouldn't be able to make the argument that, you lied in the past, so we think that what you're saying now is less credible if the false statement was not voluntary, because then that actually doesn't have any impact on the person's propensity to tell the truth or not. And then another argument you could make in these cases, kind of a Hail Mary one, but that just the mere fact of a prior misrepresentation should not prevent the approval of a self-petition, because Congress, the fact that they created a fraud or misrepresentation waiver for the ground of inadmissibility specifically for VAWA-based adjustment applicants, that demonstrates that Congress knew and intended that at least some of these applicants for adjustment, who by definition they would only be able to adjust if the self-petition was approved, so it shows that they intended that some of these folks be able to adjust status despite the fact that there was a history of fraud or misrepresentation in their record. So a blanket policy that anybody who had ever made any type of false statement can never be credible and never receive a VAWA self-petition, that's not consistent with the overall scheme of the INA. Next slide. So evidence of qualifying relationship. So a big change is the requirement. USCIS now saying it's a requirement. So before I think they said should, now they say must submit evidence of termination of the abuser's prior marriages. So not just the survivor, but also the abuser. And we have actually seen reports of this on our listserv. If any of you have received requests for this type of evidence, please do let us know in the chat, because this is something that we're keeping track of. If there's a situation where the survivor is unable to get the abuser's, for example, divorce certificate because of abuse, they should explain why in their statement that they're unable to do that. And then consider if there is alternative evidence of termination. So for example, if the survivor is able to get a copy of their marriage license application, and there was a question that the abuser had to answer under penalty of perjury that was like, are you free to marry? That is compelling evidence that prior marriage was terminated. The survivor, if they have a relationship with the officiant, the person who married the survivor and the abuser, they could see if the officiant is willing to write an affidavit about their knowledge that the abuser's prior marriage had terminated, or just other affidavits from people who know the couple and had knowledge that the abuser's marriage ended. And then finally, you could also include in the survivor's statement some evidence that would support the intended spouse rule for the VAWA self-petition. So that is the rule that allows a self-petitioner to be approved even if their marriage to the abuser is invalid, as long as that marriage was invalid solely because of the abuser's bigamy. And in order to support that argument, you'd want to make sure that the survivor has evidence of the elements for that exception in their affidavit. So the first is that the survivor would have to state that they did believe, in fact, that they did marry the abuser. They would have to present evidence that there was a marriage ceremony. They would have to present evidence that they subjectively believed that the abuser was free to marry them. And fourth, that the only reason for the invalidity of the marriage is the abuser's bigamy, so that there was nothing that the survivor did to make the marriage invalid. Regarding birth certificates, which that would come up in a VAWA child or parent case, you'll see that USCIS is casting doubt on birth certificates that are not registered contemporaneously with the birth, which we all know that does happen sometimes. Doesn't mean that the relationship is fraudulent, but USCIS is casting doubt on those. These won't be an auto bar to establishing the relationship, but if you have a late registered birth certificate, important for the survivor to explain, to the extent that they have knowledge, why it was registered late, and then to also try to get secondary evidence like hospital records of the birth, a baptismal certificate, school records showing the parent-child relationship, other medical records from the doctor, listing the parent as the parent, just in order to better establish that relationship exists. Next slide. So the next update is that, and a very big one, is that USCIS said in the policy manual that the abuser must have USC or LPR status at the time of the abuse. So this is a pretty big change because USCIS had never taken a firm position on this before. Their justification for this position is matter of LLP, which held that the abuser in a VAWA cancellation case, so about a totally different form of relief, must have been a USC or LPR at the time of the abuse. In the policy manual, USCIS didn't offer any reasoning for why they embraced LLP, whose reasoning is based on a statute with a very different structure than the VAWA self-petition statute. If you're kind of nerdy like me and you look at the two and you compare them, the way that they're written is very different, and it doesn't necessarily follow that just because it says that first cancellation, it means the same for VAWA self-petition. The difference in the statutory structures and the lack of explanation are potentially, if someone were to seek review in federal court, that could be a potential way to challenge this new requirement. And then also, after these slides were approved, the Third Circuit actually rejected matter of LLP, this decision about VAWA cancellation, in a precedent decision called Cardenas v. Attorney General. And I'm going to put that citation in the chat for folks. We have not yet seen how USCIS, like whether they're considering the fact of this decision to impact this rule that the abuser has to be a USC or LPR at the time of the abuse. I'd argue that in the Third Circuit that rule should not apply anymore because the sole basis for it in the policy manual was matter of LLP. And in the Third Circuit, matter of LLP is no longer good law. Again, we're not sure how USCIS would treat that argument, so it is still a little bit risky to file for someone whose abuser did not have status at the time of the abuse. But if the survivor understands the risks and potentially is looking towards review in a different forum, that is something that you can consider. The policy manual also appears to apply a stricter definition of battery or extreme cruelty than the agency previously used. So they reference dictionary definitions of batter that mention repeated blows, which is troubling because there's an implication there has to be repeated physical abuse incidents. And when talking about the term extreme, they reference definitions including the phrase to the utmost possible degree. So again, appearing to apply a heightened standard in terms of what is extreme cruelty, what is battery. They also removed a bunch of examples of potential battery or extreme cruelty that the policy manual had previously included. So but one thing that is helpful is that USCIS, they did maintain the focus on when you're defining extreme cruelty, the question, is the abuser attempting to attain compliance from or control over the self-petitioner? So you can still use that framework when you're trying to present evidence of extreme cruelty, but just keep in mind that USCIS will probably be scrutinizing cases that do not include physical abuse more so than perhaps they used to. You can, of course, still argue for a broader definition of battery or extreme cruelty, especially given the purposes behind the VAWA self-petition, the regulations, which very clearly do not require physical abuse, and also Hernandez v. Ashcroft, which is in your materials. It's a Ninth Circuit case, so not precedent for any of you, but still a really seminal case on the definition of extreme cruelty. And these are all arguments that you could make. But we see though that USCIS, the takeaway from this is that they are moving away from survivor-centered adjudication practices, and we can't assume anymore that VAWA adjudicators are going to have knowledge of DV dynamics. So it's really important to include materials on DV dynamics, the power and control wheel, other materials about the basics of how abuse works, especially if your case does not involve physical violence. If the client saw a domestic violence advocate, really important to include a detailed letter of support from that advocate, which contains information about what the client share with them and why the advocate thinks that those specific instances are domestic violence based on the advocate's knowledge and experience working with survivors. And you might also consider research articles, or in some cases, if this might be difficult, but if possible, expert affidavits from advocates or others who reviewed the file and have experience with abuse in particular communities, like, for example, the LGBTQ plus community. But again, just really important to include for every case evidence about DV dynamics, because we can't assume anymore that these adjudicators are going to have that knowledge. Next slide. Joint residence. So this is perhaps the biggest and most consequential change because it's a complete 180 from the policy that was in place from 2022 to 2025. So now USCIS is requiring that joint residence occurred during the qualifying relationship. So for example, if the abuser and the survivor were married, have to show that they lived together during the marriage. Litigation had been filed against USCIS when this was their policy in the past. So this was their policy before 2022, and that litigation was successful. So that suggests to me that this policy, someone might litigate again against this policy, and it also might be susceptible to arguments. Again, these would have to be made in a different forum because USCIS has already decided that these changes are retroactive. But because this is a complete 180 from the agency's previous policy, might be susceptible to arguments that it cannot be applied retroactively to petitions that were pending on December 22nd of 2025. Again, though, all that said, those arguments will not work at the USCIS level. And if the petition is denied solely because of the joint residence not occurring during the qualifying relationship, just keep in mind that the survivor will likely be NTA'd if they are not lawfully present. So that's an important consideration. In some of these cases, VAWA cancellation could be an option because that form of relief actually doesn't have a joint residence requirement at all, let alone during the qualifying relationship. Next slide, please. So for good moral character, one thing that USCIS said that was particularly significant is that conduct resulting in mandatory detention will be a negative factor in the GMC determination. And they don't distinguish between criminal and non-criminal basis for mandatory detention. So again, we would love to hear in the chat what you all have been seeing, but this suggests to me that if a person entered without inspection and was subject to mandatory detention because of that, in light of the BIA decision from last year, USCIS seems to be implying that because of that EWI, the person might lack good moral character. That would be a very, big change from the past where many folks who had an EWI were able to obtain a VAWA self-petition. We have not seen a decision from USCIS actually holding this yet, but it is something that we are monitoring and something that we want folks to keep in mind. Similarly, mandatory detention now with the Lake and Riley Act, simple, charges for theft, for example, even if the person is not convicted, now could lead to mandatory detention. But I could see USCIS potentially saying that those acts also could defeat good moral character. USCIS also noted that if the person doesn't disclose their criminal history, even if it's not material to eligibility, like, for example, criminal history outside of the 3-year period, that's not an aggravated felony, USCIS still says that will be considered a negative factor and could cast doubt on the credibility of all of the evidence in the case. So they're kind of treating it like having ever had a false statement in the past, we're going to look negatively at your entire application. Same with if the person doesn't disclose all of their past criminal history. So a good practice for survivors to disclose that history in their affidavits, even though the form doesn't actually ask about it. USCIS has also placed a lot of emphasis on their ability to consider acts outside of the 3-year period if they're relevant to a petitioner's good moral character, and that the passage of time alone may not be enough to demonstrate good moral character. They focus on factors like rehabilitation and how severe the past conduct was, and then also removed some favorable language from the prior version of the policy manual that talked about adjudicators having to consider the totality of the evidence, including positive factors, when there are bars outside the 3-year period. I would still say important to include all that positive evidence, regardless of what the policy manual says, but just keep in mind that they are looking more closely at acts outside the 3-year period. Next slide. Another big change, USCIS has stated that they might deny a self-petition without first issuing an RFE. So this brings us back to, I think it was like 2018, 2019, when they had the policy of denying without an RFE or NOID. So this makes it really important to include multiple pieces, if possible, of credible evidence for each element at the time of filing, rather than relying on being able to supplement later on. Obviously, sometimes you have to supplement, like if you're on a deadline, but in general, really important to file well-supported petitions at the outset so you can avoid, hopefully, a straight denial without an RFE or NOID. Another thing is that it appears that field office employees who are conducting 485 interviews can revoke self-petitions, and there is no, unlike in the past, there is no longer an agency policy that forbids them from asking about the abuse in an adjustment of status interview. A couple responses to this. First, the regulations generally require a notice of intent to revoke and an opportunity to respond. So a revocation on the spot should not be permitted. And I'm going to put that regulation in the chat. And then second, and I would go to every interview with that citation and argue again that because of that, a revocation on the spot is not permissible. And then about re-adjudicating the self-petition, even though there is no longer like a policy to point to, I would still argue that discussing specific facts about the abuse itself is irrelevant to a 485 interview, which is about, whether they meet the requirements for adjustment of status. And that also USCIS already had the chance to assess the evidence of abuse and to ask the survivor further questions about it through an RFE or NOID. And then also if the survivor has a therapist who's willing to attest to trauma it might cause them to have to talk about the abuse in an interview, it would be helpful to bring in an attestation from the therapist to the interview. Next slide. So now we're going to do a hypo. We have Devika. She entered the United States without inspection, and she is married to an abusive U.S. citizen, Paul. They share a 4-month-old child, Tyler. Paul told Devika that real mothers nurse and don't work, and that he would have her deported if she tried to get a job. She has issues with her milk supply, but Paul refused to buy formula for Tyler or give Devika money for formula. Desperate to feed Tyler, Devika shoplifted formula while Paul was at work. She was arrested, but the case was recently dismissed on speedy trial grounds. So then there's 2 questions here, and folks can put their thoughts in the chat. How might the arrest impact good moral character? And how would you discuss this with Devika? Seeing Lake and Riley Act, mandatory detention issues on GMC. Due to Lake and Riley Act, Devika could be subject to mandatory detention, which would bar her from establishing GMC under the policy manual. Shoplifting now triggers mandatory detention. Right. Yeah, everyone's really on the right track here. So there's a couple reasons why USCIS might say that the arrest implicates good moral character. First is just the fact that Davica was arrested, period. As I'm sure you've all seen many times, USCIS places very heavy weight on arrests, even if they don't result in a conviction, even outside of any questions about the Lake and Riley Act. And then the second issue is what a lot of you have been mentioning, that theft is one of the offenses in the Lake and Riley Act, and Lake and Riley Act detention does not require a conviction. If you wanted to get really technical about it, one way you could respond to this, if USCIS were to issue an RFV, for example, is to note that the policy manual uses the term resulting in mandatory detention, not subject to. We'd want to double check, but it doesn't look like from this hypo that Davica was actually detained in an immigration detention facility. She would simply be subject to mandatory detention. So you can argue that, at least under the policy manual, that should not be a reason for lack of good moral character because she wasn't actually detained. Regardless of this, you can also respond by mentioning the connection to the abuse of the offense. That's always going to be a good idea if you can establish that connection. And then you can also argue that behavior that Davica engaged in because of the abuse, which of course is something that she cannot control, that does not have a bearing on her character because character is necessarily something that a person controls. And actions that are taken in response to outside forces that are outside of the person's control, they cannot fairly be considered a negative force, negative impact on someone's good moral character. All that said, good moral character is a discretionary determination, and discretion is tightening across the board. So even though there are really good arguments that this should not impact Davica's good moral character, especially because throughout the INA, there are examples of Congress treating offenses related to abuse more leniently. For example, the VAWA good moral character waiver, the VAWA cancellation good moral character waiver, the deportability ground waiver for domestic violence offenses that are related to abuse. Like, there's lots of evidence in the INA that Congress intends for these to be treated more leniently. And those are all really good arguments to make. But I would also say be sure to include lots of evidence of positive equities and not just rely on the fact that there is this connection to abuse. Next slide. Retroactivity, won't spend too much time on this because again, this was really only going to find any type of potentially positive response in a forum outside of USCIS. But there is this test on whether an agency rule can be applied retroactively. And, a lot of these factors would go against retroactivity, especially, I think, for the joint residence, because that's just a total 180 from the prior practice. And if you wanted to see an example of how these factors are considered in real life, the decision on 237A1H waivers, matter of forjo, which is in your materials, the BIA actually decided not to apply their new interpretation retroactively, and they used this test. So you could take a look at that decision just to see how those factors are applied in real life. Next slide. So practice tips, again, I can't stress enough the importance of evidence about domestic violence dynamics, particularly where there is no physical abuse. Corroboration, also going to be important. Even if you can corroborate small things, like the survivor's statement that they were at the doctor on a particular day, that helps enhance their overall credibility. And that's really important if your actual evidence of the elements of the abuse is only the survivor's statement. If you can't obtain the corroboration, the survivor should explain why in their declaration. You want to make sure that isn't just in your cover letter, that it's also in the declaration. And then you also want to put in your cover letter the reason behind the any credible evidence standard. And there's some good legislative history on this. The National Immigrant Women's Advocacy Project, or NUAP, if you go to their website, they have some good legislative history materials. And be sure to brief that in your cover letters because there used to be language in the policy manual about why the any credible evidence standard exists. It's not there anymore, so we can assume that adjudicators, especially new ones, won't know why that standard exists. So important to brief, that this exists because there was a recognition that folks in abusive relationships might not have the same types of evidence that people who are applying for regular family petitions would have. And you'll also want to argue why the survivor is credible, even if there is no corroboration. So, looking at USCIS's own criteria for what is credible, is the statement detailed? Is it internally consistent? Is it consistent with other documents in the filing or in the survivor's A file? Or have inconsistencies been explained, and argue that it's still credible despite not having the corroboration? And that goes to my next point about reviewing for consistency. Again, we've always encouraged that, but it's even more important now because inconsistencies will affect how USCIS looks at and considers the credibility of other pieces of evidence. And then, if possible, I know it's difficult right now with FOIAs being rejected for using the attorney address, but if possible, try to know what was filed previously with immigration if the survivor has a record with USCIS, because if the survivor says something in the VAWA filing that is inconsistent with what is in their A file, USCIS might not consider them as credible. And then regarding supplementing pending cases, since you now have to show that joint residence was during the qualifying relationship and that at least some of the abuse occurred when the abuser was a USC or LPR, make sure that your evidence on those elements makes it clear when exactly those things occurred. So like make sure it's clear that the abuse occurred when the abuser was a USC or LPR. Make sure it's your joint residence evidence shows that the joint residence was during the marriage. And if it doesn't and it's a pending case, we would encourage you to supplement, especially since the USCIS has said that they could deny without an RFE or NOID. And then finally, kind of just reiterating if there's any good moral character concerns, include evidence of positive equities in addition to any arguments about connection to abuse or trauma. Next slide. Now we will pause for questions. So I see a question. Someone said, do you have a brief bank on the any credible evidence purpose or standard and or on retroactivity? I don't think we have a brief bank on retroactivity specifically. Christina, sorry, it looked like you were trying to say
No,
something.
it's true. I was excited to share our page on our website for the VAWA Self-Petition, which does have a lot of discussion of any credible evidence and legislative history, and a couple of good arguments that I think are in here in some old practice advisories, et cetera, because this is old work that we're being forced to do again. So I'm actually glad that it's still here on our website. We do not have materials specifically about retroactivity, though, I think.
Yeah, no, thank you, Christina, for sharing that page in the chat because I did not have that handy. About retroactivity, I mean, you could look at, like, it's not specifically obviously about this issue, but you could look at circuit precedent on retroactivity, either in the immigration context or not. For those of you who are in the Third Circuit, I don't have the citation off the top of my head, but I could look for it when Christine is presenting. There was a favorable decision saying that BIA's change in the definition of CIMT theft could not be retroactive. So you could take a look at that and see how the Third Circuit thinks about retroactivity. And if you're in the Third Circuit, maybe use some of those arguments.
Someone's asking, in addition to the PA linked above, are there other materials for this session? I think apart from,
Yeah.
yeah, you know better than me, Kelly.
No, I'm sorry. But so Maria, my colleague, she sent, I think, there were a few late registrants, I think, but to almost everybody who registered, she should have sent around a link to the index of materials as well as the slides. But if you did not receive that email, you could reach out to me. I'll put my email in the chat and I can send it to you afterwards.
We also have a policy alert on the 1367 policy manual updates that may have also been shared, but I'm just putting that in the chat before we get started with that section.
Yeah, sounds good. Thank you. And then I guess, sorry, I marked it as answer, but I hadn't answered it yet. So there's a question about if survivor knows that their spouse was a USC or LPR during the relationship, but has no primary evidence of that. What secondary evidence might they be able to obtain, or what arguments could they make about why they cannot obtain this evidence? If the abusive spouse was a naturalized citizen or LPR, would it be appropriate to ask USCIS to check their own records regarding proof of the abuser's status? It's a good question because this does come up a lot. And we've heard that USCIS has started asking for evidence, even in a situation like you described, where the person is a naturalized citizen or LPR, and obviously USCIS has evidence of that in their systems. So if the person, like, if USCIS should have evidence of their status, you can certainly ask USCIS to check their systems. USCIS should do so. I don't have it off the top of my head, but I could look for it when Christina's talking. There's a regulation that says, yeah, that they will check their systems, and that still exists despite this guidance.
And I'm gonna be really nerdy right now. I just happened to remember it from a discussion that we had yesterday, but it's footnote 26 of the policy alert that I shared
Okay.
earlier on the VAWA self-petition, not the VAWA policy manual update. But you can also share that in the chat when we find it again.
Yeah, thank you. In terms of But I think it is also good to not just rely on USCIS checking their systems, because it is technically, it is the survivor's burden to meet the elements of the VAWA self-petition. The survivor can say in their affidavit, why they think that the abuser is a USC or LPR. Like, did they see a US passport? Did they go to the naturalization ceremony? Have they seen the abuser's green card? If the abuser, again, this might be difficult to obtain, but if they're able to obtain it, if the abuser was baptized, often the baptismal certificate will say where the person was born. That would be helpful if the abuser was born here. If the abuser was in the military and the survivor's able to get their military records, that would probably have information about their birthplace. USCIS deleted as a type of evidence that someone could present of this element, but I would say, you could still submit it anyway. If on the marriage certificate or on the marriage license application, it says where each spouse was born, and especially if the marriage license application, it was under penalty of perjury and the abuser said they were born here, I think that's compelling evidence of their status. And then in all these situations, if also affidavits from people who know the abuser and know about his status or her status, their status. And then in all these situations, like if all you have is just the survivor saying, I know that they're a USC or LPR because of whatever reason, the survivor should say why they're not able to get that other evidence. And then we'll move to Christina.
Thanks, Kelly. Whenever I do these trainings with Kelly, I always learn so much. And I'm reminded so much about the VAWA policy manual updates and like associated authorities. So thank you so much, Kelly, for all of that and best practices. So we're going to turn now to 1367 policy manual updates. Let's go to the next slide. There we are. These, I put the link to our policy alert in the chat. I'll label it more clearly. Wait, is this it? I don't know. Kelly, can you put it in the chat? I seem to have lost it again. But I want to first start off by noting that they were also made effective as of the date of their release, which was December 22nd, to all pending and newly filed applications. So some of what Kelly discussed about retroactive may also come into play when we see these changes being implemented. Now let's go to the next slide. Yeah. Thank you. So before we really dig into what the policy manual changes were, Give a little bit of background. Seven isn't like something that comes up every day necessarily in discussion and training about VAWA protections or U or T protections. The 1367 confidentiality protections, as they're known, were enacted in 2006. Most of us have known them to be applied fairly broadly to essentially like protect access to all information about the survivor's applications from any outside inquiry, and also to protect the survivor against the abuser's efforts to manipulate the immigration process by sending in information or making negative allegations about the survivor's credibility. The slide here shows what the specific language of 1367 is. It encompasses these two provisions that apply to all protected persons, meaning those who have U, T, or VAWA related applications. The first is the prohibition against the use of information furnished by an abuser or perpetrator to make an adverse determination of the non-citizen's inadmissibility or deportability, subject to an exception where the protected non-citizen has been convicted of certain crimes. We'll talk about that in a minute. The second provision here is the prohibition against disclosure of information relating to the protected person to anyone outside of these agencies, DHS, DOJ, which includes the Immigration Court, the Department of State, with limited exceptions not relevant here. But previously, as I said, USCIS applied 1367 to just prohibit reliance on abuser-provided information so that any info that was provided by an abuser or perpetrator would be viewed as inherently suspect for all purposes, basically. And that USCIS had sort of implemented this in such a way that they would really make an effort to obtain independent corroborative information from unrelated third-party sources, non-prohibited sources, before making any adverse determinations against the survivor based on the information. So the policy manual changes that are most significant apply to the first provision here, the prohibited source provision. And in these policy manual updates, the USCIS announced its intention to apply the provision as written, which means far more narrowly. And so it's going to be hard to challenge the change in a change in interpretation that hews more closely to the language of the statute. But I suspect in any case that they had not implemented it literally because it is incredibly difficult to do so. And we'll talk about that. So survivors who applied for VAWA under this broader interpretation and are now adversely affected by the change in policy, I'd be interested to see what those decisions might look like, but they may want to explore arguments that it should not be applied retroactively to them. We're not going to talk a lot about the non-disclosure provision, so I want to note up front that DHS has always interpreted the non-disclosure provision to allow for the different subcomponents of the agency to share information about covered applications or covered people. So that means that USCIS has basically always been able to disclose that information to ICE. This is not a change in interpretation. And the non-disclosure provision contains an exception for legitimate law enforcement activity. But again, that means that's separate from the subcomponent of ICE. And even in those cases, they are required to maintain the confidentiality of the information to the extent possible. Let's go to the next slide. Is that 18? Yes, thank you. So again, what's significant about the new sort of 1367 guidance is that it no longer reflects that view that info provided by an abuser is inherently suspect, except when determining inadmissibility and deportability, which is not really essential determination of eligibility for survivor-based immigration benefits. So what this means is that when it comes to the elements of relief like good faith marriage that don't have to do with admissibility, abuser provided information can now come in without this like inherently suspect like thumb on the scale. And the PM now says that adjudicators can consider that abuser provided information without requiring or without seeking independent corroborating evidence, only by evaluating it using like established practices for determining credibility. This means including like such practices include like the motivation, however apparent the motivation is, motivation of the source, the reliability and the credibility of the statement in the context of other evidence in the record. So like what Kelly was talking about earlier, looking for, seeing whether the statements provided by an abuser are inconsistent with something else, whether there are gaps that can't be explained, things like that. So the policy manual also states that officers retain discretion to corroborate such statements by third-party sources on a case-by-case basis. So they can still do so. They can still apply this sort of like higher scrutiny of abuser-provided information, and you can quote that language back to them. Filers who, receive RFEs or NOIDs or decisions that do rely on that derogatory information should review it carefully for credibility, should challenge it on that basis, and encourage USCIS to treat it as inherently suspect. Could be also important to note the section of the policy manual that deals with derogatory information. That requires USCIS to allow for the applicant an opportunity to respond to derogatory information provided by an outside source. And that is in a section of the policy manual that relates to evidence and evidence generally. So I'm going to put that link here so y'all can see where that is. And it's at G in that link. Let's see. There's also regulation that requires that the applicant should have an opportunity to rebut any information of which they were not aware. That is in a regulation, the language of which I will also add here to the chat to the extent I can submit it all. There it is. Okay. It says the decision will be adverse to the applicant or petitioner and is based on derogatory information considered by the service. Blah, 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 blah. He shall be advised of this fact and offered an opportunity to rebut the information and present information on his or her own behalf before the decision is rendered, except as provided in those paragraphs. So I would take a look at those as well if you suspect that USCIS is relying on derogatory information provided by anyone, but especially an abuser, that they may not otherwise treat as inherently suspect. So the 1367 provision as written also includes this weird exception that allows DHS to consider abuser provided information for inadmissibility purposes, like determining admissibility if the survivor has been convicted of an offense under INA 237A2, which relates to deportability, not admissibility. And even if that offense has nothing whatsoever to do with the information that's being provided, or even the application being filed, or even the beneficiary's propensity for truthfulness. So, for example, if someone were previously accused of or convicted of fraud, a fraud offense or something like that, I could see an argument potentially for considering that as part of the information relating. We know it would be related to good moral character, but the offenses, we'll see the offenses at 237A2, they include much broader kinds of criminal convictions. And survivors applying for VAWA U or T relief are usually also, it's also weird because they're usually affirmatively seeking an immigration status rather than defending against charges of deportability. So it's just weird. It doesn't really make sense why they chose 237A2 and not like a 212 section to include here to limit the applicability of 1367 protections to survivors. Let's go to the next slide. So let's look more closely at this. My hope is that really no one will really need to know this. I haven't really seen it come up in TA or in discussions on the listserv, but I think it's important at least to know what it says. So if you look at the actual statute, 237A2 covers more than criminal convictions. It includes also non-criminal grounds and admissions too. But for the purpose of the exception to 1367, we are looking only at grounds that require convictions. These include CIMTs, aggravated felonies, controlled substance offenses, except for that single offense of simple possession of marijuana. It includes firearm offenses and crimes of DV also, although at A7 also does allow a waiver of DV related to portability where the survivor was not the primary perpetrator of DV. So if anyone is unlucky enough to have to grapple with this section of 1367 and their client has one of these, has a DV offense that might trigger this, I would argue for the waiver to be applied wherever it can be. But my hope is that DHS will not, officers will not sort of take the time to parse through all of this. Another thing that we've noted is that several of these offenses, because they relate to deportability, include after admission language. So again, we don't really know how this will be applied or how courts might apply it if challenged. But to say, if it does come up, we urge folks to really cite to the text and argue that if their client has not been admitted, the subsection should not apply. So that would mean, making a distinction between survivors who arrived iwi and those who overstayed their visas potentially. So again, I hope that kind of argument does not need to be made. Unfortunately, there is some precedent for applying these deportability provisions to limitations on eligibility, like admissibility and other background like criteria for eligibility. And that's in the context of cancellation of removal that happened in a Supreme Court decision in 2020 in a case called Barton v. Barr. Not clear to me how this will come up again, as I said, but could come up possibly through VAWA cancellation cases and would have to be raised up through BIA appeals to the circuit or in APA litigation. Again, it's going to be really difficult to prove, I think, or really document how USCIS is making its decision according to these policy updates for 1367. But I do have a poll. We have a hypo and a poll. So let's test our knowledge a little bit. Ali is married to Soraya, who's an abusive LPR. He does not have any convictions. Soraya has frequently threatened to call ICE on Ali. Ali filed a VAWA self-petition, and he's worried that USCIS might find out that his marriage to Soraya is not in good faith, or might find, not find out, excuse me, might determine that his marriage to Soraya is not in good faith if she calls ICE and says that he only married her for a green card. So are Ali's fears well-founded? Let's talk about how to apply this. Okay, in the interest of time, I'm going to move on, but everyone is responding yes. And unfortunately, that is true. Okay. Thanks, everyone. As we said, the narrowed interpretation of 1367 applied now allows DHS to consider derogatory abuser provided information to determine eligibility for relief. However, as I noted before, Ali should be provided an opportunity to contest Soraya's accusations. Okay. Let's move on to the next slide. We're going to get to questions in just a few minutes, so I will keep an eye on these hands raised, but also feel free to add them into the chat. The 1367 Policy Manual update also contains these additional changes that I know are super important to survivors, unlike all that stuff we just went through, hopefully. But USCIS has stated that the registration and change of address requirements do apply to protected persons. That's people filing UNT and VAWA applications, and that protected persons are not excused from providing a physical address when required. Unfortunately, we're seeing a lot of examples of people whose applications are being rejected because they have not provided a physical address on the form and used confidential instead. However, we are advising people to, if their clients are in shelters or otherwise have a safe address that is in the form of a PO box, that they provide proof of that in along with continuing to indicate confidential in those fields. The USCIS has stated that 1367 protections end when the person naturalizes. This is something I think we all assumed before, but they have clarified that here. They say that they might consider abuser provided information when considering denaturalization, but that's the only change as opposed to after denaturalization proceedings begin. So this kind of before and after like denaturalization consideration. Hope we don't have to see that either come into play. It also says that USCIS has implied that attorneys or accredited representatives can call the contact center without the non-citizens. So that's the one bright spot in all of this. Let's go to the next slide. And once again, we're at practice tips. Yes, what can I say? Recognize that USCIS will, going forward, apply this prohibited source provision fairly narrowly. Recognize that some criminalized survivors will not receive any prohibited source protection as limited as it is. Argue that information provided by abusers and perpetrators and traffickers is not credible. Consider arguments against retroactivity, prepare arguments about why certain criminalized survivors should still be protected. That's the after admission language. So pay attention when this stuff comes up, go back and read very closely the statutes and regulations involved. And be prepared to request that derogatory information and FOIA and fight that FOIA if you can. I think we're ready to go to questions again, and then we just have a few more minutes. So I want to just briefly pause here, and then we'll get back to Kelly.
I did see a question come in though from the Q&A about how do the 8 U.S.C. 1367 protections impact FOIAs when a G28 legal rep is filing on behalf of survivors with the G28 attached alongside the survivor's consent form and DOJ 361. I will admit to not knowing what the DOJ 361 is, so I'm sorry about that. I
Is that
think
the FOIA form?
okay, that makes sense. I mean, I would think that if you have a G28 and the survivor is given permission to give the information, then I think that they should provide the information to you via FOIA. I believe that like the 1367 protections can be waived by an adult petitioner in writing. I mean, I would think that if they signed something saying that that DHS or DOJ can give you documentation, then that would be kind of like waiving the protection.
I see that the DOJ 361 is a certification of identity. So proof of identity, the survivor's consent, the G28. I don't think these 1367 policy manual updates change anything with regard to FOIA processing. And in the past, I've always had success receiving FOIAs with survivor consent, receiving copies of the file, I should say. So I hope that's helpful. If anyone's experienced something different, please put it in the chat.
And then I see two other questions. Are you aware if USCIS is contacting abusers?
Oh.
I haven't seen that. Christina, have you?
No, but it just may be a matter of time, unfortunately. I don't know if they are specifically contacting abusers, or if they would specifically contact abusers, or if they would only do so if there was abuser provided information with contact information, right? Or something in the file like related to some kind of offense or family court proceeding, something that triggered like an inquiry from USCIS. But I don't think something that doesn't have that kind of information should necessarily trigger that kind of inquiry. That's my hope.
Yeah, I think that makes sense. And like they shouldn't be providing information about they shouldn't be disclosing the fact that the survivor has filed
Exactly.
a petition because that's the
Exactly.
non-disclosure provision and helpful and like, luckily that provision doesn't have any exception, even if the person like it doesn't have an exception for someone who's been convicted of one of those 237 offenses. I
Exactly.
mean, they could try to use the information they receive, but that like we would definitely want to know about it if they contact told an abuser that the client has a petition pending.
Yeah. Is there any indication those are similar changes will also apply to evidence required now for 765V applications? I recognize they're under different statutory schemes, but utilize similar VAWA framework. I think that is a really excellent question. And I do believe that these changes to sort of evidentiary requirements will also impact 765Bs. But I don't know, Kelly, what do you?
Yeah, no, I agree with that. I think the statute that is like created the 765V says that like those petitions will be considered under the framework in the VAWA
Yes.
statute. So yeah, I agree that like VAWA policy manual updates to how USCIS interprets INA 204, I do think would be moved over to 765V. So yeah, that
This
makes
is why I just love presenting with Kelly. I always learn something new. But yes, and also they are considered protected applicants for 765B.
right. Yes, thank you for that reminder. Yeah, so 1367 would apply to them. I'm just getting a reminder that we are at
We
time.
have to go.
So we will let folks go. Sorry about that to the interpreters. So I hope you all found this helpful. Thank you so much for your participation, and we hope to see you soon.
Can you just show that last page with our email addresses?
Oh, yeah.
And you guys have those slides with your materials, so they have information about how to request technical assistance from us. So thank you so much, everyone, for joining.
Thank you.